The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good morning. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon. I'll be presiding today. Also with me are Judge Jeff Carpenter and Judge Fred Gore. We have one more case on the calendar this morning. It's the case of Pedlow versus Kornegay out of Mecklenburg County. And we will first hear from the plaintiff appellant's attorney, Mr. Rayner. And I understand you're going to reserve 10 minutes for rebuttal, if that's correct. And
yes, sir. That's correct.
Well, you can begin when you're ready.
Thank you, Your Honor. Good morning again. May it please the court. My name is Ken Rayner of the Mecklenburg County Bar, and I represent Mr. Pedlow, the plaintiff appellant in this case. I would just start out with the observation that it is axiomatic that a cause of action accrues and the statute of limitations begins to run at the time which a party becomes liable. The statute of limitations does not begin to run until the plaintiff is entitled to bring a suit against the other party.
Mr. Rayner, I don't want to jump in on you so soon, but I guess is reading your brief and the analysis, I guess I want to make sure I'm having you provide clarity to your argument. So are you couching your argument that it's not actionable on that particular document? Because would you not agree that there had been some meeting of the minds and some agreement of monies transferred or conveyed that would have been actionable by themselves without the document, correct?
Yes, Your Honor. There were advances made by Mr. Pedlow to Mr. Kornegay that predated the date they first started talking about the note, which I think was in July of 2008. And Mr. Pedlow could have made an action on those advances. They would be demand loans. They would have a statute of limitation of 3 years, as I understand it. They were not secured by any collateral, unlike the note. However, once the note was signed, that became a new obligation that, for lack of a better word, replaced those underlying obligations. And that is the action that we're talking about. When could Mr. Pedlow take action to enforce the promissory note, including, for example, demanding payment of the interest, which you may recall in the note, the interest actually ran from before the date of execution. It went back to the initial advances. It also gave him the right to enforce the security. Prior to that time, he would have no right to do that. There was also an attorney's fee provision in the note. If he brought those other suits, brought a suit on those other advances, he would not have had the right to enforce a claim for attorney's fees, as I understand it in North Carolina, because that does require an exception to the general rule is that you can't recover attorney's fees. And so this contract was a new and separate obligation, and that is what we were talking about. When did he have the right to enforce the obligations, including enforce them by bringing a lawsuit? I hope that addresses your point. And the general rule in North Carolina has been for many years that the quote, the note, when executed, becomes evidence of a contract, new or continuing, from which the statute of limitations would have begun to run. And that's right out of the Irvin v. Harris case, North Carolina Supreme Court decision from 1921, 109 Southeast 2nd, 867. This court in Wells versus Barefoot, 55 NC App in 1982 said, the statute of limitations on an action on a promissory note payable on demand begins to run from the date of the execution of the note. And I would say it is important, I think, to note in these cases when they talk about date of execution, it's obvious and implied that they mean execution and delivery to the beneficiary or somebody else who can enforce the note. Like I have a case in South Carolina now where parties negotiated a contract they exchanged documents, and the plaintiff was giving a document. He signed it, but he instructed his attorney, don't deliver this until we resolve these other issues. And that act, because he didn't deliver it, or his attorney didn't deliver it, means that no signed contract was in existence, and therefore the statute of frauds would apply. So signature and execution really involves, some, and I would quote the Irvin case, which was talking about delivery in that case. And they basically said the acts which consummate the delivery of a promissory note are not essentially different from those required to complete the execution of a deed. And they go on to say, did the maker do such acts in reference to the deed or other evidence as events an unmistakable intention to give it effect and operation according to its terms and relinquish all power and control over it in favor of the grantee or obligee? And in this case, that required signature and delivery of that note. And I would just point out the obvious, but it's important to note, Mr. Gavigan, the attorney for Mr. Pedlow, sent numerous versions of this note to Mr. Kornegay, all according to Mr. Kornegay with the same date on it, the date of July 30, 2008. But until he signed that note, my client couldn't have demanded that he make those payments. He couldn't have demanded attorney's fees if he filed a lawsuit. All of that became effective only once Mr. Pedlow signed it and returned it. And I don't know the reason why Mr. Kornegay, I don't know why Mr. Kornegay didn't return it at those points, but it's obvious that if he had not signed it and returned it, there would be no right of action on the note. And that goes back to the point, consistent with the case law, when could Mr. Pedlow have made a claim on that note? When could he have filed a lawsuit? And to me, it's obvious it's only after the instrument is signed. The common law, we've had many cases under the common law for demand notes, both signed under seal and not under seal, that say the statute of limitation runs from the date of execution. I do not see any reason why the UCC would change the application of that common law. And that is particularly true when in North Carolina, unlike most states, but in North Carolina, we have a particular subdivision to our version of the UCC. And this is, which deals with statute of limitations on promissory notes. And this is statute NC Gen Stat 25-3-18 H, which says a sealed instrument otherwise subject to this article is governed by the time limits of GS 147(2). And of course, 147(2) is the statute of limitations applicable to sealed instruments. And so all that case law that had been decided under 147, to me, I think should be applicable under this provision. And that is particularly true when you look at 25(1-103) under the UCC, subsection B, which says, unless displaced by the particular provisions of this chapter, the principles of law and equity, including the law merchant, law relative to capacity, etc., supplement its provisions.
And maybe you said this, or there's something to break under 1-47. I'm just kind of looking at that rule. I mean, that statute, which has been around forever. Is there a case that talks about it's when it's signed and not so much when the date of the contract?
There is no
Just under the
case.
common law. Just the common law. Yeah, what's the common law rule with that?
There is no common law. There's no case where the issue as presented in this case was date of the typed on the document versus the date it was executed. The only parallel that I could find was the case law that talks about presumption of a deed and the date on a deed. And in the White versus Farabee case, 713 Southeast 2nd 4, which was a 2011 case for the Court of Appeals. The issue in that case was color of title, which is essentially a statute of limitations issue. And in that case, the deeds were dated a date that was different than what everybody, all the uncontroverted evidence showed. They were actually signed by the last grantees and delivered to the grantors. And so the question in that case was, does the deed date control the color of title issue, or does the date it was actually signed and delivered? And the court in the case pointed out that the delivery of the deed is the final act of its execution. It is that which gives it force and effect, and without which it is a nullity. And so the court went on to say that while the date typed on that deed may be a presumption of when
It can be overcome. It can be overcome.
It can be overcome. And I would point out that the old version of the UCC did have a date provision, and it included a provision that said the date is the date of the document, but it also had a presumption provision that said, you know, you could, the presumption could be overturned. Now that date provision was eliminated as I understand from the commentary to the official UCC commentary was unneeded, but certainly it would appear that given the statute, the UCC's current provision that incorporates the general principles applicable to law, that it would make it seems to me entirely logical that the presumption as it does for deeds would exist. And that's particularly true when I go back and as I was preparing for this argument and I was reading the Urban case where they were talking about, you know, the delivery of a note being analogous and very closely related to delivery of a deed. I mean, they're treating a note and a deed pretty much the same. And so it would appear to me that the same argument applies that, and again, remember, we're talking about the date for a specific purpose here. It would be one thing if the note said interest runs from the date typed above. We're talking about the date that the statute of limitations begins to accrue and when you can bring a lawsuit. And that's, I think that is an important distinction to.
Mr. Rayner, the last line of the note reads, in witness hereof, maker has executed this note under seal as of the day and year first above written, and that is July 30, 2008.
That's yes, Your Honor, that's what it says. But the witness, the person who signed that document, acknowledged that was not the case. He acknowledged he signed it on July 2nd, 2009. Just like in the case about the deed where there was a presumption that the date controlled, but it was rebuttable, that similar language was used in that document.
The difference in that case was we were talking about a deed. In this case, we're talking about a promissory note where the UCC is in play. I mean, it's an instrument that falls under the UCC, and under 25-3-113, the UCC provides that note can be post-dated or annotated. It's basically whatever the agreement of the parties is, isn't that right?
Well, Your Honor, I would just point out that in this case, there was no agreement that this note was going to be annotated or post-dated.
How do we know that from the four corners of the document?
We do not know that from the four corners of the document, but we do know that from the testimony of the plaintiff and the defendant. They had no agreement that this document was going to be post-dated or antedated. They did not discuss that. So this is not a case where they said, we are going to give this document effect as of this date. Mr. Pedlow said he didn't even realize the date was different. Mr. Kornegay basically said he realized the date was different and assumed it had some significance, but he acknowledged he had no conversation with anybody about that would support a contract. And then I would also point out, Your Honor, that at the same date, he signed a document, a security agreement, that would be July 2nd, 2009. He signed a security agreement that acknowledged that he was going to pay the money under that note.
Mr. Rayner, on that point there, before you get to that security agreement, I think is where you're heading. So your argument and in response to Judge Carpenter's question is that there should be no effect of the antedated provision under 25-3-113. And I got a follow-up question to your response. So that's a no, that we shouldn't give that any effect?
Your Honor, it is, I do not see anything in the UCC that says for an antedated or postdated document, you give it some certain effect. And particularly, there is nothing in the UCC that says you give it the effect of measuring when the statute of limitations begins to run on that document. And in this case, that date was there, it appears, by the accident of the drafter. And so just like you could have an antedated and a predated, you could have an undated document. We normally think of checks being that way, but sometimes people forget the date documents. If that was the case, is the answer there would be no statute of limitations, or there would be no ability to bring a lawsuit. But the UCC does not say that an antedated note or a predated note has to be determined, the statute of limitations for a suit on that claim has to be determined by that date.
All right, so let's take it for effect that counsel should have changed the date. It didn't, and say the 30 July 2008 is controlling. What effect under 1-26 does this security agreement? What effect does that have?
I think if one is taking the position that the note date typed on the note is the effective date of the note for the statute of limitations issue, you cannot ignore 1-26 and the clear language in the security agreement that acknowledges the debt and acknowledges the obligation to pay it. And so even if the note date typed on there controlled, 126 would be an acknowledgement of the obligation that would extend that statute of limitations beginning from that date, the date of the security agreement. I was not able to find a North Carolina case directly on point, but if you look at the North Carolina case law on what it takes to acknowledge a debt, it is, we see it with language a lot less definite than that security agreement. Like, one case, it was basically on a financial statement, it showed the debt. Another case, it was a letter basically acknowledging the debt. But I did present the Pennsylvania case where they basically said the security agreement was an acknowledgement of the obligation that extended or told the statute of limitations. So again, I think if somebody's going to say, if the defendant's going to say, well, that note date typed on their control, then they can't ignore 126 and the effect of the acknowledgement by the security agreement. And I would also point out that Mr. Kornegay, this kind of belies any argument he would have that he intended the note to be dated a year earlier when the documents contemplate even date, and he writes in July 2nd, 2009 as the date of that security agreement. He's actually the one that put that date in there. And so
now, I have a question. The 13th offense raised by the defendant raises as an affirmative defense payment. That's one of them. Was there any evidence that any payments were made toward the $84,000 debt between 2009 and when the complaint was filed? Or there's no evidence of any payments?
There was no evidence of any payment. That was brought out in Mr. Kornegay's.
So he never paid anything. Okay. Okay.
Mr. Rayner, the promissory note, the language of the promissory note references a security agreement of even date herewith. The promissory note is what you get to sue to collect on, not the security agreement. Correct? Promissory note is the operative instrument.
Well, the promissory note is the document that the security agreement is being used to secure, I guess the way to say it. But yes, if you don't have a promissory note, then you have no obligation to secure by the security agreement.
And the security agreement actually references in paragraph 1, the note dated July 30th, 2008.
That's correct, it does.
Okay. All right. Thanks, sir.
But I would point out to your point, Your Honor, about the effect of a date. And I do acknowledge that the date typed could have significance for very particular purposes. For example, if the note said, the interest will run from the date typed above, or the date of the note, or if it said it would be due from so many days from the date typed above, then it would be a demand note, correct? But the issue here, this is, I think, an important point to make. We're asking, when did the statute of limitations start to accrue on this claim? And the point that I'm trying to make is, regardless of what date was typed, no cause of action could have been filed on that note at all. You could have typed a date 10 years in advance. You could have typed a date 10 years before, or you could have had no date. But once it was signed, before it was signed, no cause of action accrues. Once it's signed, regardless of the date typed on there, the statute of limitations begins to accrue at that point. And under 1-47, it's 10 years. And 1-47 doesn't say 10 years from the date typed on the document. It says 10 years, and the case law has interpreted that to be execution, and I would add execution and delivery. And so I do think it's important to be cognizant of what we're using the date for. It may be effective on other things, but for the purposes of measuring the accrual, when it starts, and measuring the 10-year period, I would contend to the court, regardless of what date is there, that 10-year period can't run until it's actually executed. At this point, being I have 8 minutes, unless you all have other questions, I'll reserve my time for rebuttal.
Thank you. Thank you for your argument. We'll hear from the appellee.
Thank you. May it please the court, I am Michael Messinger of the Law Offices of Michael Messinger. I represent Tim Kornegay, the appellee. Pedlow filed an action seeking to enforce a promissory note payable on demand pursuant to the express terms of that note that was drafted by Pedlow. The note stated, in witness whereof maker has executed this note under seal as of the day and year first above written, and that day and year first above written is July 30, 2008. Now, actions to enforce promissory notes that are payable on demand are subject to a 10-year statute of limitations set forth in Chapter 25, Article 3, Section 118B, which states, if no demand for payment is made to maker, an action to enforce the note is barred if neither principal nor interest on the note has been paid for a continuous period of 10 years. And here, Pedlow did not demand payment until May 3 of 2019, which is more than 10 years after July 30, 2008, the expressed date of execution set forth in the note. So despite the foregoing, Pedlow filed an action seeking payment of principal and interest from the date that the loans were made. Pedlow argues that the statute should run from July 2, 2009, the date that Kornegay put pen to paper agreeing to the terms of the note, including the amount, the interest rate running from the date of the loans, and of course, the date of execution of July 30, 2008. Pedlow makes this argument despite the fact that this July 2, 2009 date appears nowhere on the note, and it contradicts the clear terms of the note that Pedlow himself drafted. Those facts are not in dispute. So Kornegay filed a motion for summary judgment, and far from being reversible error, the lower court ruled in Kornegay's favor. So,
Counsel, do you deny or do you agree that the note was executed under seal?
the note was executed under seal. Yes. However, it is still a negotiable instrument that is governed by Article 3.
So what is your argument of how 25-3-18H should apply as it pertains to the statute of limitation?
Sure. So 25-3-118H says it says a sealed instrument otherwise subject to this article is governed by the time limits of 1-42 section 2. So the sealed instrument remains otherwise subject to Article 3. It's just that the time limit or the length of the statute of limitations is increased to 10 years. Now, actions to enforce a promissory note payable on demand in which no demand has been made already have a 10-year time limit. So Section H has no effect on our specific matter. In other words, sealed and unsealed promissory notes payable on demand in which demand has not been made have a time limit of 10 years. And in fact, if we look at comment 2, it states if a note is payable on demand, there are 2 limitations periods. It does not say there are 3 limitations periods as is contended by Pedlow, because of course, one of the limitations periods is already 10 years. And I would note, I think it's clear that the legislature would not write or adopt a whole chapter, an article, much of it dealing with promissory notes, and then remove the vast majority of promissory notes from its control if the note bears something that's commonly found on promissory notes. Okay. Right. So, okay. So this section, so promissory notes are negotiable instruments governed by Article 3. Article 3 has a specific statute of limitations, and it's established law that a more specific statute of limitations prevails over general statute. So the first thing we're going to do is we're going to look within the chapter for a statute of limitation. And if it's there, that's the statute that we're going to apply. And if not, then you can look outside for a more general statute of limitations. So that statute in this case, again, is 25-3-118B. So this section 118 replaced section 122, which was entitled accrual of cause of action interest, which stated a cause of action for payment on a demand note accrued upon its date, or if no date is stated, on the date of issue. So you will notice that this section 122 sounds very similar to section 113, which is entitled date of instrument, which states an instrument may be antedated or postdated. If an instrument is undated, it's the date of issue, but only then. So here's the point. If section 118 drastically changed section 122 from a cause of action for a demand note accrues upon its date to Pedlow's argument of a cause of action accrues when it's signed and issued, even if it is dated, we would see something in the comments section or in the legislative history letting us know of that sea change. Instead, there's nothing like that. Rather, we have comment 1 to section 118, which tells us to look within Article 3 for the accrual date. And when we do as instructed, we see former section 122 essentially verbatim in section 113, which is supposed to state the instrument can be antedated or postdated, and the date of issue only matters if the instrument is undated. So how did Pedlow arrive at this date? So Pedlow's argument is really a 3-step process. First, we must find that promissory notes made under seal are not subject to the UCC or Article 3. Second, having removed the note from the UCC in Article 3, we must apply section 147.2 to the exclusion of the UCC in Article 3. And then finally, having arrived in Chapter 1, we can now apply Section 115 and Section 126 to find when the statute of limitations accrues. So this game of logical leapfrog defies the clear language of Article 3 in Section 118 and common sense when, again, one considers Pedlow's argument, which would render Article 3 inapplicable to the vast majority of promissory notes which are signed under seal. So let's walk through this argument, which requires that we leave the UCC in Article 3 almost right away. So Pedlow relies on Section 118C, which states that a sealed instrument otherwise subject to this article is governed by the time limits. So I believe that I might have already answered this question. So to use my time wisely,
You got 22 minutes, so you got plenty of time.
Okay, thank you. So I guess let me walk through that then.
So counsel, let me make sure I'm following your argument. So
Sure.
is it your contention that there, in the current version of our Article 3, that there is or isn't a specific statute of limitations or accrual?
There is. There
Okay.
is.
And which section of Article 3 are you saying, or are you pointing to that provides that language?
Sure. So we had the prior article, Section 122, gave us the
Let's look at the current article.
yes, Your Honor.
Let's stay current.
Yes, Your Honor. Yes, Your Honor. So that article gave us a accrual date, right? But it didn't tell us the time period. Now that was replaced with Section 118, which gives us the time period of 10 years. And then you look within comment 1, it tells us to look within Article 3 for the accrual date. And when you do that, you see Section 113, which is essentially verbatim to the accrual statute, and it tells us to look at the date of the instrument. We look at Section 112, which tells us that the interest is going to run from the date of the note unless it runs at an earlier time period pursuant to the terms of the note, as is the case here. So I think, when you look at everything that the UCC is trying to do and what other courts have stated about the UCC, the purpose is so that we can look and stay within one article and one chapter.
So basically, your semantical jousting is noted, okay? But is it fair to say that in essence, in the true spirit of statute of limitations, that there's very little, black letter language enumerating a quote unquote statute of limitations in the current version? Is that? We have to look from comment to then. So it's in essence, it's been removed from this true spirit of quote unquote statute of limitations.
I wouldn't go that far,
okay.
because I think when you look at what courts in other states have said about the purpose, it's clear that they want us to have a self-contained article. And then you do look at comment 1 and it says stay within Article 3. So I would argue that no, they did do it. Could they have done a better job? Sure. But I think that they did it.
So the reference in 118H as it points to 147.2, what is your contention of that language in light of your contention that we have to look at the comment in other section?
Sure. Okay. Sure. So that is saying to look at the time limit set forth in 1-47.2. So that time limit is 10 years. The legislature, after the date that this UCC is adopted, could change the time limit for instruments under seal to 15 years to 20 years. This is saying whatever, when it's under seal, we're going to go with the time limit that the legislature says for that document. But it's just a time limit. It says nothing about accrual. So that's where this game of logical leapfrog comes in. Now we look at that. We're outside Chapter 1. Now we're looking at Section 115. Right?
When would we be tasked with determining when the time limits began if accrual is a separate issue?
I'm sorry, Your Honor?
It appears as though you're trying to separate the issue of accrual from the terminology of time limits, and accrual is necessarily involved in determining of time limits, is it not?
Yes, it is, but time limit is different than accrual, right? Again, looking at section 220, former section 221, they gave us the accrual, right? But they didn't give us the length of period of time. Now we have section 118, which gives us the length of period of time, tells us to look within Article 3 for the date of accrual, based upon the obligations of the parties. And the only obligation of Kornegay as the maker is to pay the note, and pursuant to the terms of the note, he agreed to the terms of the note, and he said, "Yep, I'm going. The amount is $84,000. Is going to accrue interest at 10% per annum. It's dated as of July 3rd, 2008. It's going to run from August 2006 to October of 2007. That's the note that we have to look at to determine whether neither principal nor interest has been paid for a continuous period of 10 years on the note." And so that would be my response, Your Honor.
So, counsel,
Yes.
say we look at just the four corners of the document. There's deference given to the 30 July 2008. How do you reconcile this signature on the security agreement, even though it references 2008 document? How do you reconcile that with the black letter language of 126 of not being a new promise, which would start the statute of limitations run again?
Sure. Okay. So this argument again requires that we're looking outside the UCC. And so Pedlow is arguing that Kornegay's execution of the security agreement constitutes an acknowledgement of a new or continuing obligation to pay the note pursuant to 126. So Pedlow admits that this is an unusual application of section 126. In fact, this would be an unprecedented application. So section 126 states, "No acknowledgement or promise is evidence of a new or continuing contract from which the statute of limitations runs, unless it's signed in some writing signed by the party to be charged thereby. But this section does not alter the effect of any payment of principal or interest." So this section 126 does not apply to our situation. First, the statute appears in chapter 1, not chapter 25, article 3, where we are instructed to find the date of accrual, and it uses the word contract, not instrument. Second, 126 explicitly states that this section does not alter the effect of any payment of principal or interest. And again, we are concerned with section 118B, which provides that if no demand for payment is made to the maker, an action to enforce the note is barred if neither principal nor interest on the note has been paid for a continuous period of 10 years. So section 126 does not affect our determination of whether an action to enforce the note is barred, because it explicitly does not alter the effect of any payment of principal or interest. It does not affect whether principal or interest has been paid. Pursuant to section 118B, Pedlow needs a payment to extend the statute of limitations, not a document saying what will be sacrificed if Kornegay does not pay. And even assuming that this statute could affect our accrual of statute of limitations, the statute is, the title of the statute is "New Promise Must Be in Writing." And every case cited by Pedlow involves a situation where a payment was made or a new promise was signed on a subsequent and different date after the original promise. Here, the security agreement cannot be evidence of an acknowledgement of a new or continuing promise, because the security agreement was signed on the same day as the note and is referenced in the note itself. Specifically, the note states, "The payments under this note are secured by a first lien security interest in the collateral, as defined in that certain security agreement of even date herewith." So that phrase of even date herewith shows that the security agreement is not evidence of a new or continuing promise, but rather it's a contemporaneous document. And for its part, the security agreement simply sets forth the collateral that will be used to pay the note in the event Kornegay defaults under the terms of the note. It's only triggered if Kornegay defaults under the note. And here, there was never a default, as Pedlow failed to demand payment during the time in which the note was enforceable. The security agreement lives and dies by the note. It does not
All
extend
right,
the life
so
of
let's
the note.
I'm following your reasoning and your argument. So your argument is that we shouldn't pay attention to 126 because 113B controls, correct?
That's part of my argument. Yes, yes, Your Honor.
So how is it not that we should not then look at, 113H and then follow the logic of 147 applying, which is not within, the UCC? Are you telling us that we should just look at 113B and follow it and then not follow on the ultimate pointing to 147 and 118H?
Yes,
So
Your Honor.
you can't have, because that's kind of like you want us to look at B, but not look at all of H.
No, Your Honor. My argument can be looked entirely within Article 3. Again,
But 147 is not necessarily in, is 140, yes, it's sort of not within, but it's outside of the provisions of Article 25.
yes, it is, but yes,
Which is part of your argument of saying we shouldn't look at 1-26 because it's not under Article 25.
I understand your argument, Your Honor, and my response would simply be that when you look at 1-47, it's entitled 10 years. That's all it says. So now we're leaving Article 3, we're going to 147, and then we're looking at Section 115, and this is responsive, Your Honor. So when you look at Section 115, which is what Pedlow wants to apply, it states civil actions can be commenced within the periods prescribed in this chapter after the cause of action has accrued, except where in special cases a different statute of limitations is prescribed by statute. And here we have that special case in which a different limitation is prescribed by statute. And if you look at Section 118G and comment 2, I think that's instructive. That's really what I was trying to get to here. So as stated in comment 2 to Section 118, the first 6 subsections apply to actions to enforce an obligation of any party to an instrument. By contrast, the 7th subsection G does not seek to enforce an obligation, but rather deals with claims for wrongful acts such as conversion and breach of warranty. And that subsection G says that actions must be commenced within 3 years after this cause of action accrues. So that is exactly what Pedlow wishes Section B says. He wishes that subsection B said the action to enforce a promissory note payable on demand must be brought within 10 years after the cause of action has accrued. However, that is not what subsection B says. And the fact that the legislature used this language after the cause of action accrues in subsection G shows that that is not what they were trying to apply to subsection B, which would be the end result if you then leave Article 3, go to 147, and then go back to Section 115. Okay. So it's very telling that Pedlow cannot cite a single case in which a court found or even considered whether the date of the note or the date the note is signed is preferred if those dates differ. And that means one of two things. That means that every single promissory note in the United States of America that's subject of a written opinion was signed and dated on the same day, or it means that the date on the note matters. Clearly, it's option 2. So Pedlow cites Wells, Shields, and Caldwell for the proposition that the date of signing is preferred to the date of execution according to the note if those dates differ. So first of all, those cases do not consider that issue. Second, they're pre-statute, so they're admittedly of little value, but the language actually supports running the statute from July 30, 2008. Wells states the statute of limitations from the date of execution of the note. Caldwell states the note in question is dated 8 of May, 1849. The parties in making their contracts have a right to stipulate for such terms as they agree. It has been invariably held that if a promissory note is made payable in money on demand, the statute commences running from the date of the note. Shields cites section 122, and it states the cause of action accrues against the maker on the date of the instrument. So here, the in witness whereof clause, the note states, in witness whereof, maker has executed this note as of the day and year first above written, which is July 3rd, 2008. This is the note that Pedlow drafted. This is the note that Kornegay agreed to. In signing the note that Pedlow drafted, Kornegay agreed many terms, include the amount, interest, and date of execution of July 3rd, 2008. Words have meaning. This means what it says. Pedlow wants this court to commit the cardinal sin and treat this July 3rd, 2008 date as meaningless. Neither principal nor interest was paid for 10 years from July 3rd, 2008, which is the date of the note. Pedlow's action is barred. Pedlow's claim really boils down to a request for reformation. Specifically, Pedlow claims that his attorney or one of his staff made a mistake, and he wants the court to swap out July 30, 2008 for July 2, 2009. However, Pedlow is not entitled to reformation because Pedlow knew of this supposed mistake in 2008 and 2009 and had 3 years from that knowledge to seek reformation. There is no allegation that Kornegay caused Pedlow's unilateral mistake, and Pedlow needs a mutual mistake to reform the note, but Kornegay was not mistaken, and he understood that the effective date of the note, regardless of when he swung by Pedlow's attorney's office to sign, as it was put by Pedlow's attorney, was July 30, 2008. So as stated in Mr. Kornegay's deposition and in his affidavit, Pedlow drafted all the terms of the note. After much back and forth, on July 29 of 2008, Pedlow and Kornegay agreed to the terms of the note. On July 29 at 8:38 p.m., Pedlow's attorney sent the note to Kornegay to sign with July 30, 2008 already filled in, and he asked Kornegay to swing by at an unspecified time to sign the note. Pedlow's attorney then sent or presented the note to Kornegay to sign another 5 times. Each time the note was dated July 30, 2008. Pedlow himself was copied and sent these post-July 30, 2008 emails, and he never said this was a mistake. Pedlow chose not to have a line underneath Kornegay's signature where Kornegay could write the date. So taking all that together, any future holder of the note is going to have the same understanding that Kornegay had, which is that the note was executed as of July 30, 2008, and the statute will run from that date unless payment has been made, and payment has not been made.
Let me ask you this question. I don't think there's any disagreement prior to the signing of the note that there was money exchanged and there was an obligation on the monies. What is your argument to the other terms not being actionable until they have been signed within the note, such as the attorney's fees and some of the other ancillary terms? Could they have been sued for in light of the note not being signed?
So I would argue that Pedlow might have still tried to sue based upon the emails back and forth. However, my better response to that question is that once pen was put to paper, once Kornegay put his signature on that note, he agreed to all terms in the note. He agreed to attorney's fees, interest, the amounts. So once that happened, that's what matters. And if you look at the note, it says date of execution of July 30, 2008.
Mr. Messenger, go ahead.
Go ahead, Judge.
Question. What do you contend the event of default under the note was in this case?
There was no default. There was never because a promissory note payable on demand can only be defaulted under if there's a demand made, and there was no demand made during the time that the note was enforceable.
Well, the security agreement says that upon an event, this is under the remedies and rights upon default, subsection B says that upon an event of default under the note and under this security agreement, the lender may exercise, in addition to all other rights and remedies granted to it in its security agreement, any and all other instrument or agreement securing, evidencing, or relating to the obligation under the note, all rights and remedies under the Uniform Commercial Code. So it appears as though the documentation expanded the rights otherwise available under the statute of limitations. And I think you're correct that the event of default on a demand note would be demand and then a failure to pay upon demand. So Mr. Rayner's argument is the demand was made in May of 2019, and that was the default.
There can't be a default because this is an action to enforce a promissory note, and a promissory note is enforceable only during that 10-year period, right? An action to enforce a promissory note is barred if neither principal nor interest has been paid for a continuous period of 10 years on the note. And
Whether demand is made or not, whether demand is made or not.
correct.
Yeah, 10 years. Yeah, if it's a demand note, I can't have a demand note and wait 50 years from now and say, hey, I'll demand it and I can enforce it. If it's a demand note, it just starts right when it's signed or the date of the note. That seems to me to be the issue here.
Right. And again, I would argue that when you look at the note, it clearly shows date of execution, July 3rd, 2008. And again, there's not a single case in the United States of America involving a promissory note payable on demand where the courts even discussed those 2 days differing. So we must give the language on the note effect.
Right. But the demand, I agree with Judge Dillon in regards to if it's a demand note, it happens when the note's issued. And you're saying, well, you can't get a reformation, but it appears as though the party agreed to a reformation in regards to the later executed security note expanding the rights upon default.
So everything that the security agreement says, if you look at it, it says upon default under the note, upon default under the note, upon default under the note. If there's no default under the note, the security agreement is not implicated, and the security agreement would have no power. It would have nothing to enforce. It's there to enforce the obligation under the note. Once that obligation ceases to exist, the security agreement has nothing to do. So
if I sign a note and it's secure with my house and the note is not under seal, but the deed of trust is, and you don't sue me for 3 years, can't you still foreclose on the property if it's within the 10 years?
Yes, Your Honor, but
I think that's what Judge Carpenter's saying is you might not be able to sue for payment of the money, but can you enforce a security agreement? Does that have a different statute of limitations? That's what he's asking.
Thank you, Judge Dillon. That was much more eloquently stated.
I think that's what you're asking, and I like to hear the answer to that too.
Thank you.
Spend a minute or two. I know your time's run out. Let's spend a minute or two on that question.
Yes, Your Honor. So it's very different. A note secured by a deed versus a note secured by a security agreement are two very, very different things. A deed is a separate document in and of itself. It comes with a right of foreclosure, with equitable rights. That is not a security agreement.
Well, doesn't a security agreement give you the right to grab this whatever the security is and sell it to satisfy your debt? How's that different than grabbing the real estate to satisfy a debt?
Because there's actually quite a bit. Let me see if I can find this here. There's quite a few cases on this actually, involving. I'm not going to be able to find it, I don't think, but the cases that talk about this talk about the difference between a mortgage and a security agreement, and what they talk about is basically how a deed is a separate and distinct document that essentially, or the mortgage is a separate and distinct document that has a life apart from the loan, whereas the security agreement is upon personal realty, not on land, and it essentially lives and dies with the
You're just saying the rules are different. Okay, I got you.
They're very different, and I'm so
Okay.
sorry that I don't have all that in
That's
front of me.
all
I wrote
get
a
it. Well, go ahead and wrap up real quick so we can move on. So just go. I'll give you a minute to wrap up if you want to.
Okay, yes, please. So the last thing I would like to say on this matter is that, okay, so we need to render this decision thinking about why the UCC exists. And here's how another court has discussed Section 118. They stated Section 118 is designed to define the time within which an action to enforce an obligation, duty, or right arising under Article 3 must be commenced. The purpose underlying its adoption is clear: to increase uniformity in the law of negotiable instruments across the state, such that parties need not look beyond Article 3 to determine the applicable time frame within which to file suit. So if we were to apply Pedlow's secret, subjective July 2, 2009 date that appears nowhere on the note and contradicts the express terms of the note, this would fly in the face of those purposes and require significant inquiries to verify that each and every term of the note is correct. And we would have to consult many chapters outside the UCC. So based upon the foregoing, I respectfully ask that the court affirm summary judgment in favor of Tim Kornegay. Thank you very much.
Thank you so much. And we'll hear rebuttal.
Well, thank you. Again, I contend this case boils down to a simple, very simple issue. When did Mr. Pedlow have the right to enforce a note? When did he have the right to file a lawsuit to recover monies that were promised to be paid under that note? And I think the answer, and raised by one of your questions, it wasn't before that note was signed. There's no rights to sue under that note until it's executed and delivered to the lender. And that is consistent with longstanding case law under just a common law in North Carolina. Excuse me. The appellee wants to ignore that case law by making, and I'm still lost at the convoluted exercise that the appellee's attorney went through to explain why subsection H does not apply in this case. The language is clear, and I would just make a quick diversion. You know, most states have a UCC statute of limitations provision applicable to notes that doesn't have subsection H. Our legislature, for whatever reason, adopted and added subsection H to our version of the UCC, and that language is clear. It says under 3118H, a sealed instrument otherwise subject to this article is governed by the time limits of GS 147(2).
Well, let me ask you a question. Let's say that the note was signed before the date of the note, and then Mr. Pedlow sold me the note. So all I have to go by is the date on the note, and then I tried to sue Mr. Kornegay, and he raised his defense. Wait, I signed that thing long before that. I mean, am I bound by that? I mean, would the rule you're asking us to do with that? I mean, or should the rule apply differently for good faith, bona fide purchaser for value? If I bought the note, would I be bound by whatever date Mr. Kornegay said he signed it? Let's say he signed it in 2006 and the note says 2009 and I sue him in 2018 and I bought the note and I'm relying on what's on the note.
But a good question, and this kind of goes to the four corners, I think is what you were getting at, argument. Even if you bought that note, you would not know everything you need to know. For example, you wouldn't know if a demand had been made or not. You wouldn't know if a payment had been made. And assuming under subsection B, it's not signed under instrument, remember, the time limit would be expanded if there's a payment made. The time limit would be expanded if there's a demand made within 6 years. So you have all of those issues. And of course, you would have that issue here as well. There'd be a complicated issue, and that is the date versus date signed. I assume commercial transactions, people are going to have warranties and contractual documents to protect them. But I don't know that you would be a bona fide purchaser for value if you bought a note that said it was secured by a deed of a security agreement of even date, and you didn't even look at the security agreement. And if you looked at the security agreement, you would see it had a different date on it. And so, yes, it does cause some issues, but I would argue that if you were a bona fide purchaser, you would have defenses that Mr. Kornegay does not have. That bona fide purchaser may have those, but Mr. Kornegay does not. He signed it. He knows what he signed it. So that's an issue that doesn't apply.
Okay, go ahead, continue. Thank you.
But going back, I think the appellee's effort to avoid subsection H is they want to create this issue. Well, there's no payments made within 10 years, and that's the magic marker. The magic marker is subsection H, which refers us to 1-47, and that is the general statute of limitations that applies to sealed instruments. And there is no reason that the legislature would put that into the statute of limitations applicable to negotiable instruments, and then specifically you carve out sealed instruments other than that was their intention. We're not going to use A and B, subsections A and B. We want to use 1-47. By the way, under the common law, sealed instruments before the UCC, and I forget which case it is, but I believe it's McClutchin versus McClutchin, applied the very issue that we're talking about in terms of date of execution in a case that was a negotiable instrument, but before the UCC applied. Now, so the answer is you have to look at 1-47 and then ask yourself, when could a lawsuit have been filed? I noticed the appellee wanted to give short rift to 1-26, and it is important to remember what 1-26 does is it only requires a written document to evidence the acknowledgement of the debt. In other words, the new contract or the acknowledgement has to be in writing under 126. Under the case law that existed before that statute, the people were arguing acknowledgements were made, but they were not necessarily in writing. This statute said it has to be in writing.
I mean, the case is just, I wish there was a case that was on point. I mean, I'm looking at a case from 1857 where Justice Nash said, it has been invariably held that if a promissory note is made payable in money on demand, the statute commences from the date of the note and no special demand is necessary. But I mean, that issue might not have been before. I mean, we just have cases that just kind of say when it's executed and some that say that. And there, I guess y'all are saying there's just nothing directly on point. I can't believe this is a case of first impression in the United States, but
it's funny. I think Mr. Messenger and I, either one, if we could find the case, we would present it to you. I feel pretty comfortable in saying that. I will say, I think this is one of those cases where no good deed goes unpunished. And that's why you don't see this case law. You don't see this conflict. As evidenced in Mr. Pedlow's deposition, Kornegay was his friend. He made the advances. He was his friend. Most commercial banks don't wait 10 years, to enforce a note. In fact, most commercial banks don't have a demand note. They move quicker than that. And
but so it's the law. We need to apply the law. So it is what it is. So
so I think the law here has to be based on when could this cause of action, when could you have filed a lawsuit on that note, and I think the answer to that is certainly not before it's signed and not before it's delivered, and that is the question we're asking. Not when the interest accrues or when you could demand a payment of interest, but when you could file the lawsuit to enforce the note. And certainly in looking at that, you have to look at the security agreement, which constituted at least an acknowledgement of, as of a year later, that that note was valid, and that told the statute of limitations. And I'll be glad to answer any questions you have. Otherwise, I'm through.
My last question is this: Can parties by contract change the statute of limitations?
Yes, Your Honor, I'm comfortable in saying that because I'm familiar with the case law, and I know there's case law where parties to a contract have reduced it to 2 years. for example, instead of 3 years on a general breach of contract. But that would require, negotiation and a specific intent to do that.
Okay,
That was
that's
not
fine.
true in this case.
Okay. Thank you all for your arguments. If there's any more questions for Judge Carpenter or from Judge Gore? Okay, well, thank you. We'll take this under advisement, and I'll ask Mr. Sword to adjourn court.
Yes, Your Honor.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you.
Thank you.